All right, welcome back to the second half of our year in review, and we'll start with this little gem. Even a combination of innocent facts, when taken together, may warrant further investigation by the police officer. And that is a very important concept in law enforcement. Innocent facts. One fact alone might not mean anything, or taking each of a series of facts independently might not mean much. But when you put them all together, I was found behind a store. That is a completely innocent fact of absolutely no criminal activity, the fact that I was behind a store. It happened to be a store that was closed at the time. The store was closed and is an innocent fact. Put it together that I was behind the store, however, and now we start to see something else. It was 3 a.m. That's something else. I have a history of burglary offenses. Okay, that doesn't mean I'm committing a burglary now. However, I was found in possession of tools that are commonly used for burglary. Oh, it's getting sweet now. And it goes on and on and on. Even a combination, some of those weren't innocent facts, obviously, but you get the idea. When you take a combination of innocent facts together, they may warrant further investigation by the police officer. Where do we fail in this area? We fail to document. We fail to tell the court what these factors were or what we knew at the time. Once we start doing that, we're going to have a much easier time, ladies and gentlemen, in court. When we tell them all the innocent facts together and how our training and experience put to those facts under a totality of the circumstances allowed us to come to certain conclusions. All right, our next bottom line. A person, therefore, has a reasonable expectation of privacy with respect to the contents of such a closed container that he owns, even if he did not have any expectation of privacy that was violated by the search of the place where it was found. This comes up quite frequently when someone gives consent to search a vehicle, but they have passengers, and the passenger leaves a pocketbook or a book bag inside the car. The owner of that pocketbook or that book bag does not give up all reasonable expectation of privacy in that just by virtue of having gotten in a car. They take the bag with them. We're going to need separate consent if they do that. However, closed containers within a vehicle, all right, if we've got consent to search the vehicle, and we have no reason to believe that this person is expressing a desire to keep their closed container closed and private, we can continue to search under consent. Would it be better to get consent for the closed container? Yes, it absolutely would. That could not possibly hurt our case if we do that. Do people give consent to open containers even knowing there are drugs or other contraband inside? They absolutely do. If they tell us, no, we do not have permission, now we have a choice. Do we seize the vehicle and get ourselves a warrant? Do we have enough to do that? If we don't, it might just be the case that today is the day they go free. But we always remember that old maxim law enforcement that is so important and so apropos here. We only got to be lucky once. They got to be lucky every single day. We will get them sooner or later, ladies and gentlemen, if it's contraband they have inside there. It might just be they have, dirty underwear in there, literally, that they don't want us to see. But if they've got contraband, sooner or later they'll screw up again, and we'll be there all waiting. All right. Under the Fourth Amendment, pursuit of a fleeing misdemeanor suspect does not always, that is, categorically justify a warrantless entry into a home. That was not always the case. This is a case that came up within the last year, all right? U.S. Supreme Court case, as a matter of fact. Pursuit of a fleeing misdemeanor suspect does not always justify a warrantless entry into a home. Just because we're searching someone doesn't mean we can follow them into their home. The case was some nitwit out doing donuts in his car, then drove into his garage and shut the garage door behind him. And an officer squeaked inside before the door got completely closed. The question was whether the officer had a categorical right to enter. The court didn't say whether he did or didn't have a right to enter. It said that we're not going to categorically say every officer in pursuit of a misdemeanor suspect has that right. We're going to look at them individually. So if you are chasing a misdemeanor suspect and they enter a residence, you have to ask yourself, do you have enough to continue pursuit? All right, what are some of the things that you're going to be looking for or some of the reasons the court will find that you have reason to pursue? All right, the fact that this is someone who is known to you and this is not their residence. The fact that you have prior indication that this person, these misdemeanor offenses are a danger to themselves or to others, like DUI as an example. These are some of the things that the court is going to look at. They're just not going to allow us automatically, that is categorically, to enter residence. I think I missed one. No, I didn't. This is an important one that I told Peter I would bring up. One that I'm not an expert on. There is a growing area of research. Let me read you just one of the many cases that came up when I took a quick look at this for Peter. A study of the Phoenix Police Department published in Police Quarterly compared officers working 10-hour shifts with those who worked more than 13 hours. Longer shifts didn't result in fewer arrests or field interrogations, nor did they hinder pass rates on shooting tests. But the number of complaints made against those in the 13-hour group was significantly higher than for the 10-hour officers. Excessive overtime and mandatory overtime, ladies and gentlemen, is something that's coming back to haunt us and it's coming back to hurt us. The longer the shift, the longer the mandatory overtime shifts or the additional shifts that we're making people take without a break, the more likely that these bad things are going to happen. In some of these studies, like the one that I'm referencing here, you don't see a diminishment in the amount of actual work they're doing or in their ability to put rounds downrange on target. But in some of the cases, they are. There is no question, however, it goes without saying that the jury is not out on the question as to whether excessive overtime, excessively long shifts, or double shifts, or no days off for long periods of time adversely affects law enforcement. It absolutely does. I know that there's no easy answer to some of these questions, especially with budget constraints. But if the question comes down to whether we hire additional officers or whether we pay time and a half, that's an easy mathematical conclusion to come to. It might cost us a bit to get a new officer and to get them up to speed, but ultimately the time, the money that is saved, and the exposure to liability is going to be a lot less. The most important factor, however, is we're going to see a lot less officers get injured, especially in things like auto accidents, areas that require the operation of a vehicle being one of them, that higher level of concentration that is adversely affected by excessive overtime or mandatory overtime, something to keep in mind. All right, another bottom line. Probable cause does not involve certainties, but rather the factual and practical considerations of everyday life on which reasonable and prudent men act. If the smell of fresh or burnt marijuana is involved, list all the other factors. The case underlying this particular bottom line obviously had that as part of it. The smell of fresh marijuana alone is not going to be a standalone factor because so many Pennsylvania residents now have the right to carry medical marijuana on their person and in their vehicles. However, the smell of burnt marijuana does continue to be a standalone factor. That said, I don't care whether we have burnt, fresh, or both. We're going to document both those facts and every other factor that led us to this conclusion. The person has heavily tinted windows. We activated our lights and siren and they didn't stop for an additional 30 seconds. We saw people moving around in the back of the vehicle. Even though we couldn't see through the windows, we could see the vehicle itself shimmying and shaking as we approached, which was indicative to us of people hiding substances in the car. We saw the corner-tied bag. We smelled the marijuana, like I said, fresh or burnt. The person admits that they smoked marijuana in the last hour, day, month, year, whatever it happens to be. All these things. Give them all to the court. In the cases where evidence is suppressed, the court is hanging its hat on a failure of the police to document properly or to testify adequately. Testifying, we can take at least half the blame on that one, but we're going to allow some for the district attorney as well. But you can tell by reading these cases that the blame the courts are finding is on the police, that they always seek some area where we were deficient in what we documented or how we documented. So we're going to want to give the court as many of these factors as we possibly can. Give them no good reason to suppress. If they're going to suppress anyway, that's on them. We'll be lucky one of these days. Number next, when it comes to consent, again, consent comes up over and over again. The presence of an express admonition to the effect that the citizen subject is free to depart is a potent objective factor. All right? Can't be much clearer than that on consent. When you tell them you don't have to stay, you can go. In whatever words you choose. That is a potent objective factor in deciding whether or not the person gave consent voluntarily. Ladies and gentlemen, I had to scratch my nose, so I switched over to full screen. You like that? All right. Anyway, when it comes to consent, the presence of an express admonition to the effect the citizen is free to depart is a potent objective factor. A lot of consent cases, and unfortunately, we are using consent as a substitute for a warrant, which we should never do. If you've got probable cause, go ahead and get a warrant. It's when we lack probable cause. We are at a standstill. Our investigation can go no further without consent. That's when we use consent. That's the only time we're supposed to use consent. And once we come across something that appears to be contraband, that we see and know to be contraband, whether through plain view or plain feel, plain smell, whatever it happens to be, then we're going to stop what we're doing and secure a warrant because now we have the probable cause that we lacked before. All right, our next bottom line. However, when executing a warrant to search a residence, the police have authority to detain individuals who happen to be present. However, in order to search or arrest them, the police must establish independent probable cause. Sadly, some of the folks watching this are going to disagree with me, and vehemently so, and say when we're serving a warrant for guns or we're serving a warrant for drugs, we have a right to search everybody who's there. You absolutely do not have a right to search everyone who is there unless your warrant gives you that express permission. If you said, and search all persons present to include, and you list the targets of your warrant or the known co-conspirators in your drug conspiracy, okay, that is one thing, all right? But you need separate reasonable suspicion to pat down. You need separate probable cause to do a full-blown search for the people who are present. You don't get the right, just because I'm present where you have obtained a warrant to search for narcotics, you do not get to search my person, all right? Unless I'm named in that warrant or I'm the subject and you can say that I was one of the people who's part of that drug conspiracy. I'm the owner of the home. I have dominion and control over the entire residence, the right to exclude, whatever it happens to be. These are the factors the court's going to be looking for. All right. Please do not kid yourselves into thinking just because you're serving a warrant for guns or for drugs that you have the absolute right. Have established separate reasonable suspicion for anyone that you want to pat down, separate probable cause for anyone, or a separate container that you want to search. We don't get to go through handbags either just because we're looking for drugs. All right. Additionally, a defendant's mere presence at a place where contraband is found is insufficient standing alone to prove that he exercised dominion and control over those items. See, we're talking constructive possession. Again, it comes up. I will tell you, constructive possession cases are every month in the case law. So if you need a refresher on that, here's your cue to get one. Get a refresher on that. A defendant's mere presence at a place where contraband is found is insufficient to prove they exercise dominion and control. All right? Again, we're in a house. We see some drugs in plain view on a bedroom dresser, and there's 13 people in the house. We're not going to lock them up because they're at a place where drugs are found. We're not going to lock them all up. We're going to want to have more. Was there one of those 13 found in the room? Is that the room of one particular resident? Is there only men's clothing in the room? Are there only boots of a size 12 and only one size 12 foot in that house besides mine? Okay, those are the questions that we want to ask to show that they exercise dominion and control over those items. Just being present when something is found, all right, or being around where something is found is not going to be sufficient in the eyes of the law. The language of the Pennsylvania Constitution requires that a warrant describe the items to be seized as nearly as may be. All right? We want to describe them as nearly as may be. The clear meaning of the language is that a warrant must describe the items as specifically as is reasonably possible. This requirement is more stringent than that of the Fourth Amendment, which merely requires particularity in the description. Pennsylvania courts are going to look for, and under the Pennsylvania Constitution, they have the right to look for more particularity than the Fourth Amendment. We might get away with something in federal court that we will not get away with in Commonwealth or in the courts of the Commonwealth. So we need to describe as nearly as may be what it is we're looking for. We want that particularity, all right? We want a particularity in the description of the premises that we want to search, and if there are separate unoccupied portions thereof, like garages, like sheds, like cars in the driveway, we're going to need to describe each of those as well. We don't get to automatically search those areas, all right? Again, we'll be at the bottom of the hill looking up in suppression court if we're trying to describe why it was that we searched a car parked in a driveway that wasn't listed in the original warrant. We're going to want a separate warrant for that car, or to include the car in the warrant. Parked in the driveway is an inoperable 67 Chevy, whatever the case might be. We're going to want to give the court that particularity, and that will help carry the day. All right. We adopt the holdings of McDowell and Hanna. What did McDowell and Hanna say? Concussing someone during an assault is sufficient evidence of serious bodily injury under PS 18 PA CSA Section 2301 as a matter of law. This was a police officer who was concussed as a result of trying to take this guy into custody. The question was whether the police officer had established the offense of aggravated assault. Well, as you well know, it should have never got to that point because even a simple assault in the course of taking someone into custody, a simple assault of a police officer is going to amount to aggravated assault. But here we were dealing with 2301 and 2302, and the court said, concussing someone during an assault is sufficient evidence of serious bodily injury under the statute. All right, number next. Man, language is a little small there, but I will lean close and read it. We employ a three-prong analysis to ascertain whether the Commonwealth's evidence is sufficient to prove that a defendant knowingly violated a duty of care under the endangering the welfare of a child statute. 1, the accused must be aware of his or her duty to protect the child. 2, the accused must be aware the child is in circumstances that could threaten the child's physical or psychological welfare. And 3, the accused either must have failed to act or must have taken action so lame or meager that such actions cannot reasonably be expected to protect the child's welfare. It's a case that cited in a 2019 case, Commonwealth versus Sabalka. But I will tell you, these EWOC cases keep coming up in auto accidents where mom or dad is driving under the influence. It is not automatic, all right? It is not going to be automatic that a driving under the influence is going to result when there are juvenile passengers in the car, especially the children of the driver, all right? It's not going to be automatic. We're going to want to prove it. And we're going to want to prove if it's, first of all, that first one is where we're going to have some trouble. The accused must be aware of his or her duty to protect the child. And the second, must be aware the child is in circumstances that could threaten the child's physical or child welfare. They must be taking action so lame or meager. All right, have to show that we knew we had some obligation to these children, not just they were in the car. As ridiculous as that sounds, you're probably shaking your head. Boyle, you have lost your mind. If they're in the car, anybody who's driving that car knows they have a duty to those kids. I think so too. You would think that would be the law, but it is not necessarily without us articulating that the driver knew that they had passengers in the car. How would they know? Because it is their child or their nephew or their niece or their extended relative or the child of a friend who they had agreed to transport, or that friend is in the car as well, that sort of thing. Give the court as much as you can if you are going to charge endangering the welfare of a child. Perhaps you never thought of endangering the welfare of a child as a charge along with a driving under the influence. You might want to consider it here, but make sure you're addressing these 3 factors. All right, what's our next bottom line? Reasonable suspicion cannot be based on information discovered after the detention has begun. You might not think that's common. That is incredibly common, that we list factors that we found out later, all right, especially where we're listing the factor that this person has previous drug arrests, all right? If we didn't know that beforehand, then that does not add to our reasonable suspicion. If we only found that out after we took them into custody, that does not contribute to our reasonable suspicion. Things found out afterwards are not allowed to be used as a basis for reasonable suspicion. We have to find them out beforehand. We're still going to list the things in our articulation, in our arrest report, our incident report that we learned. However, they're not going to contribute if they were found out afterwards. We're moving right along. We got about 12 minutes left here. Let's see if we can fill it. The specific intent requirement of Section 5503A may be met by a showing of a reckless disregard of the risk of public inconvenience, annoyance, or alarm, even if the defendant's intent was to send a message to a certain individual rather than to cause public inconvenience, annoyance, or alarm. These disorderly conduct arrests, you know they trouble me. If you know me for any length of time, you know that these disorderly conduct arrests trouble me. So if the person is yelling at one person individually, but it's causing every light in the apartment complex to come on, then that is something that we're going to want to document. Just because they are directing their anger, they're yelling, their radio playing, whatever it happens to be, to annoy one person doesn't mean that they're not disregarding the risk of public inconvenience, annoyance, or alarm. So we're going to want to establish that. How do we establish that? Because we say that there were several lights came on in the apartment complex. Or someone came out and said, what's going on out here? All this noise is waking me up. See if we can't document that person's name. Even if we don't have them come to court, the fact that we took the time to identify them will count heavily in our favor. The most important piece of advice I can give on these disorderly conduct arrests, however, ladies and gentlemen, is this. When you make a disorderly conduct arrest, when you make any arrest whatsoever, where you're going to charge something in the crimes code, and anytime you make an arrest, you are. Open the crimes code. Open it up. Let me tell you, I stayed awake most nights in law school, and they required us to read that whole damn thing. And even when I would get a case, even though I had read every provision of that crimes code multiple times over and over, even though I taught crimes code for many years, ladies and gentlemen, even though those things are a fact, I still, when I get a case in or when someone asks me a question or I get an expert case I'm going to testify in, I open up the crimes code and make sure there hasn't been any changes to the statute. Make sure they haven't pulled that section that said simple assault on a law enforcement officer in the performance of their duties is aggravated assault. Make sure they haven't changed that law because the law changes. And on disorderly conduct, if you find yourself talking yourself into a disorderly conduct charge, it is absolutely the wrong charge. Move on to something else. All right. What's our next bottom line? Ultimately, what constitutes the actus reus of unreasonable noise under Section 5503A2 is determined solely by the volume of the speech, not by its content. All right. Again, I threw 2 disorderly conduct cases in here back to back for your enjoyment. All right. Be careful. Disorderly conduct. And if it is something they're saying, let's make sure our report doesn't read that we arrested them for saying that abortion should be illegal or abortion should be legal or whatever it happens to be. It's not what they're saying, it's the volume of the speech if we're charging under that A2. If we're not charging under A2, make sure that what we're describing meets the section of the statute. I'm not even going to try and summarize the sections of the statute. Why? Because like I just told you, if I had such a case, I'd open up that crimes code to make sure the facts that I had met the definition. All right, the law in court held the search of the passenger compartment of an automobile, limited to those areas in which a weapon may be placed or hidden, is permissible if the police officer possesses a reasonable belief based on specific and articulable facts which, taken together with the rational inferences from those facts, reasonably warrant the officers in believing that the suspect is dangerous and the suspect may gain immediate control of weapons. This is that wingspan search that we're talking about, a Terry frisk of the inside of a passenger compartment of a vehicle. The court is going to want to know that we had specific and articulable reasonable suspicion as to why this person, whether it's we've found them with weapons in the past, whether they're engaging in those furtive movements, something we should do our best to describe, not just say furtive, describe what furtive means. What are those super secret double probation things that they're engaged in? Describe those things to the court as to why you're saying these are furtive movements. Describe all those things that we're going to pat down the passenger compartment of the car, limited to those areas where a weapon may be placed. We're not going to open small pill bottles looking for a .357 Magnum is the bottom line there. All right, we're moving right along. Here we go. An officer may ask whether there are weapons in the vehicle, order the occupants of the vehicle to exit the vehicle for officer safety, or alternatively to remain in the vehicle until the stop is completed without reasonable suspicion of criminal activity. We maintain the right under Pennsylvania law to control the conditions of our car stop and our ped stop, all right? When we have a car stop, we can tell people to stay in the car, get out of the car, whatever the case might be. The question arises if somebody tries to leave our car stop, a passenger in the car gets out and says, I'm out of here. Do we want to stop them? We have the right to stop them. The law is quite clear on that. We have the right to control the conditions of our stop. We have the right to make sure this person isn't running around the corner to summon assistance to defeat the arrest or other actions of the police. However, do we want to? Do we want to do that? Or is that person a diversion to stop our attention or to divert our attention from the driver of the vehicle or the vehicle itself, whatever the case might be? Those are the questions that we're going to ask ourselves under the law, and something you should discuss as a squad in the context of roll call training. All right, number next. In order for the public servant exception to the community caretaking doctrine to apply, police officers must be able to point to specific, objective, and articulable facts that would reasonably suggest to an experienced officer a citizen is in need of assistance. Second, the police caretaking action must be independent from the detection, investigation, and acquisition of criminal evidence. Third, in order for the public servant exception to apply, the level of intrusion must be commensurate with the perceived need for assistance. These come up both on car stops and investigations of persons at properties, all right, where we're making entry. We are pulling up behind someone who is on the side of the road with their blinkers on, let's say, and we're knocking on the window and they're passed out in the front seat of the car with the engine running with an empty bottle of vodka next to them on the passenger seat, that sort of thing. These are the public servant exception cases under community caretaking that we're looking at. We get called to a check the well-being at a residence. We look through the front window and someone has passed out. We're banging on the window and they are not stirring, all right? What other information do we have, all right? We have the information that this person is has a heart condition, or, this is elderly mom and hasn't been seen or heard from in a while. In addition to looking for flies on the window, we're going to be looking for the person that we can actually see them. If we can see them and they obviously need our assistance, we're going to go in there and we're going to assist them. If it turns out that we also see things in plain view, okay, we see things in plain view, We are going to seize those. We're going to stop our actions when it's clear that the person was merely wearing headphones, and that's why they couldn't hear us. We saw their feet, but we didn't see their head, and therefore, oh, wait, I'm awake, I'm fine, I don't need the police. Then our actions are going to stop under the community caretaking doctrine, all right? We go only so far as we have to provide the help, and we are not there. Our purpose is not, all right, to find a crime or to find evidence of a crime. Number next, while an officer may conduct certain unrelated checks during otherwise lawful traffic stop, he may not do so in a way that prolongs the stop absent of reasonable suspicion ordinarily demanded to justify detaining an individual. Here, ladies and gentlemen, and if you are a subscriber to my monthly, you know this term, the Rodriguez moment, the moment where the mission of our car stop has been reached, has been finished. We pull someone over for a motor vehicle code violation, tinted windows, rolling through a stop sign in the South Philly slide, whatever it happens to be. We are allowed to walk up to ask them certain questions about where they're headed to or from, whether there are any weapons in the car, that sort of thing. We're allowed to ask them if they've been drinking. We are allowed to ask them certain questions, ladies and gentlemen, especially if we smell the odor of alcohol upon them. These are all part of the mission of the car stop. We are allowed to take their license, registration, insurance, return to our own vehicle, and do certain checks, including checks for criminal history and for warrants, because they do not prolong the car stop in the eyes of the law. But once we have done those things and we've decided whether to issue a ticket or not, once we've reached that point, we've reached what is known as the Rodriguez moment. And if we don't have additional reasonable suspicion at that point, then we got no business doing anything else. We should end our actions right there. Bodies of case law written on this Rodriguez moment, and something we go over pretty much every month in my monthly training, something you're going to want to go over at least every month in your roll call training if you're not receiving mine. All right. Next bottom line. Further, unprovoked flight in a high crime area is sufficient to create a reasonable suspicion to justify a Terry stop under both federal and state constitutions under the Superior Court case of Commonwealth versus Jefferson from 2004, and even more recently. This is a 2024 case, or 2023 case that cited Jefferson. All right, ladies and gentlemen, this remains the law. Unprovoked flight in a high crime area is sufficient. Presence alone in a high crime area does not justify a Terry stop. Just because it is a high crime area does not make every person we run across in that area someone who's engaged in criminal activity. And that is something important to keep in mind. Something the law will not allow is for us to perform a Terry frisk of everybody just because they're in a high crime area. But if there's unprovoked flight, they take off for no reason at all when seeing us, that is reasonable suspicion. All right. Then we have to act quickly to confirm or dispel that suspicion. Whether it's finding contraband, patting them down, finding a weapon, or something under plain field, if that's narcotics, whatever the case might be, we're going to act quickly to go one way or the other. Arrest, whatever it happens to be. All right. To maintain, he said, constitutional validity and investigative detention must be supported by a reasonable and articulable suspicion. The person seized is engaged in criminal activity and may continue only so long as is necessary to confirm or dispel such a suspicion. As I said, ladies and gentlemen, we want to act quickly, and acting quickly is the hallmark here. This is what the court is going to look for, that we did what we had to do, but we didn't throw somebody in a cell and let them sit for 2 days before we continued our check of their person or whatever it happens to be. We do what we have to do, but we do it right away. That's not to say we can't transport someone back to our headquarters for identification. That's a question that comes up for me over and over again. Yes, we have the right. We can't identify them on the street, all right, and we have some reason to hold them. Okay, what's the reason to hold them? What is the crime they are suspected of? What is our reasonable suspicion? What are we continuing to investigate? They do not have a driver's license or are not identifying themselves with someone who comes back with a Pennsylvania driver's license. We can do fingerprinting, all right? We can bring a mobile unit out, or we can take them back to our headquarters to do that. There is case law that supports doing that, but we have to act quickly. On that car stop example, ladies and gentlemen, if we are going to bring them back to our headquarters and we are not able to identify them, we're going to take them forthwith to a magisterial district justice and have a hearing then under the rules of criminal procedure. That is going to be the end of our action. That judge might order that they be held or order that they be fingerprinted, but if they're not going to cooperate with our fingerprinting efforts, that might be our last line of defense. All right. Last one, where the source of information given to an officer is unknown, the range of details provided and the prediction of future behavior are particularly significant, as is corroboration by independent police work. The corroboration requirement is based on the principle that because an informant is right about some things, he or she is probably right about other facts also, including the allegation the object of the tip is engaged in criminal activity. There's one you can go over at your own pleasure, because we have run out of time, ladies and gentlemen. As I said, we're going to keep this to an hour, and that ends our second half hour of instruction. If you have questions about your department's policies, I invite you to go through your chain of command and speak to those folks and see if they can answer your question. If you have questions about anything you've seen here today, please feel to reach out to me. Questions about policies or the need to have a policy gone over by qualified counsel, reach out to your risk management professional at DVPLT, and they will assign it to competent counsel, whether that's me or somebody second to me. All right, ladies and gentlemen, thanks. Be well, stay safe.